All right, good afternoon, and we are back. I feel like it was a commercial break. You know, after these messages, we'll be right back. Do you remember that? You remember that? You remember that? Okay. Anyway, we are here this afternoon. We are so honored to be joined by our sister branch of government, the Judiciary, and so glad to have Justices Robson and Donahue here with us. Before we start, Justices, Chairman Struzzi, do you have any introductory comments?
Yes, thank you, Chairman Harris. So I will keep this brief, but I'd like to welcome you all here. We appreciate your presence this afternoon. As I have been doing throughout these hearings, I think it's important for people who are watching or listening understand, because this is a budget hearing, the context of the amount that's in the spending proposal put forth by the governor. So I'm not going to highlight every individual court, although everyone is getting or is requesting some type of an increase. But the overall for Judiciary, based in the governor's request, is $509 million, roughly a $30 million increase, or about 6.5%. So, and with that said, I welcome your testimony, and we look forward to the questions. Thank you again for being here. Thank you, Chairman.
Before we begin, Justices, I know you have some of your judges from some of the other courts. They are in the back. They are more than welcome to come sit up front with you all, or at least sit in the back if they choose to. They don't have to sit in the back of the chamber. We definitely want to make sure that we mention them for being here as well. In the middle of the table is our timekeeper. When the light turns green, our members will begin with 5 minutes of questions for you to answer. When it's yellow, that means 30 seconds. And red, that means please try to wrap it up so we can keep everything on the time. We want to get as many questions in from our members. Before we begin, Justices, if you would introduce folks that you have here with you, and I know we have some other jurists here as well, if you would please introduce them as well.
I will be happy to do that. Thank you. I'm Justice Christine Donahue, and with me is Justice Kevin Robson, my friend and colleague on the Supreme Court. And sitting with us is our court administrator, whose name is Andrea Tuomamen. We also have with us the President Judge of the Commonwealth Court of Pennsylvania, Renee Cohen-Jubileer, and the President Judge of the Superior Court of Pennsylvania, Judge Ann Lazarus. And we also have representing the Judicial Conduct Board, former Judge of the Superior Court, Susan Gantman, who is the chair of the Budgets Committee of that board. And while I'm at it, if I may, I'd like to introduce some of our staff that we have with us today. Sitting behind me, we have Damon Wachter, who is the Director of Legislative Affairs, Casey Scarborough, who is the Director of Finance, Christine Newton, the Assistant Director of Finance, and Teresa Fikens-Sachs, who is Counsel. And with that, if I may.
Before we begin, hold on one second. So I have to swear y'all in. I know y'all justices and all that, but that's our rules. So if you would stand so we can swear you in. Do you solemnly swear that the testimony you're about to give is the truth, the whole truth, so help you God?
I do.
Thank you so much. Justice, you may proceed with your opening statement, and then we'll get to questions.
Okay, thank you very much. First, it's an honor and privilege to be here today on behalf of the Judicial Branch of Government. And we say good afternoon to Chairman Harris and Struzzi and Judiciary Chairman Briggs and Kaufman, and the members of the Appropriations Committee and members of the Judiciary Committee. We are grateful for the opportunity to address you today, and we also want to start by thanking you for your bipartisan support during the last budgeting period and the one before that. Because of the actions that you've taken, These measures put the judicial branch back on the path of fiscal stability after years of flat funding and revenue diversions by providing vital funding increases, reauthorizing statutory surcharges critical to the judicial budget, and pausing the diversion of funding from the Judicial Computer System Augmentation Account. As we say each year, adequate funding for the Pennsylvania's unified judicial system is essential to our constitutional democracy. We want you to understand that we totally appreciate the difficult job that you have in coming together on an annual basis and developing a budget for this large and wonderful Commonwealth. And that understanding comes from our colleagues on all of the branches of the judicial levels, the Court of Common Pleas, the municipal court judges, and the magisterial district judges. We want to point out again, as we know you are aware, that 75% of the judicial budget supports those courts at the county level. And these courts are the closest to and likely have to have the most direct contact with your constituents. It's imperative that these courts, as well as the entirety of the judicial system, is adequately funding to ensure that the constitutional mandate that all courts shall be open and that all persons with an injury done them shall have an opportunity for recovery. The other point that is, I'm sure, obvious to you, that like the legislature, the judicial program is not program driven. 89% is personnel. Also, like the legislature, state funding for the court budget is less than 1% of the entire state budget. The judiciary has been a good steward of taxpayer dollars and remains committed to conserving those limited resources. And before answering specific questions from committee members, I'd like to briefly give you an overview of the 3 budgetary requests for the judicial branch. They include 1, a general fund increase of 7% or $30.5 million. 2, reauthorization of Act 49, which expires on July 31 and is critical to providing operating revenue to augment the general fund line items. And 3, statutory amendments or other modifications to provide for adjustments to the Judicial Computer System Augmentation Account without levying a new fee or increasing an existing fee. Again, thank you for your bipartisan work over the last 2 fiscal years to provide the judicial branch with funding to ensure that it can uphold its constitutional mandates. We appreciate, again, the difficult task ahead of you for 2025-26 and look forward to answering your questions today and going forward in an effort to make our small piece of the budget as transparent as possible. Thank you.
Thank you so much, Justice. We're going to begin with our questions, and we're going to go to one of our attorneys on the committee, Representative Kincaid.
Thank you, Mr. Chairman. Thank you, Justices, for being here today. I want to really dig in to your budgetary request because the courts were flat funded from fiscal year 2016-2017 through 2023-2024. And obviously, at the same time, things continued to get more expensive, especially when we're talking about personnel. Can you talk about what steps the judiciary took during that time period to balance the budget?
So thank you, Representative, for the question. Certainly, one of the things that we had to do during that period of time was rely on Act 49 funds to a certain extent to plug the appropriation gap that was there. more so than we've had to have done in prior years, and that certainly had an impact on the funds that have been available to us. Certainly, we've had some magisterial district judge eliminations that happened during that time, which helped as a cost savings as well. We continued to tighten the belt where we could. This is now I guess my third year of doing these budget hearings. And again, as Justice Donahue said, we're so grateful for the bipartisan support we have received over the last several years in recognizing that there was that period of flat funding. And as the Chief Justice and I sort of promised last year, we are heading in a really good direction. We're almost there. I'd like to say that we're almost there to the point where we can come back, hopefully next year, in the absence of any additional programmatic thing that we want to expand, any additional initiatives that we want to expand, that will be more aligned with what the cost of adjustment would be from a year over year for purposes of inflation or what have you, and not be asking for the increase that we're asking for again this year. But this year we're lower than the last year, and we expect to be trending in that direction, hope to be trending in that direction. So thank you.
I appreciate that you brought up court fees. I want to talk about those, but I want to talk briefly beforehand about when you have to tighten the belt, how does that impact the ability for Pennsylvanians to access justice?
Well, we like to think that we have been able to tighten the belt without impacting the access to justice. If you want to talk about fees, I think that's an entirely separate subject, which we'd be happy to talk about. And as the Chief Justice said last year, and I think Justice Donahue would agree with me, and all the court would agree with us, we are not necessarily fond of funding the court system through a fee structure. It's just what we have. And our 7% budget request that we're making this year from the general fund appropriation is in fact in reliance on that fee structure that has been put in place by the General Assembly. The continuation of the Act 49 reauthorization is very important for that 7% to work out. But I like to think that our court, our leadership, Andrea Tuominen and her office and the AOPC, as well as our what I'll call the frontline judges, the MDJs, the Court of Common Pleas judges, despite the flat funding that we incurred over those years, rose to the challenge and didn't compromise the level of service that we provide, this important, vital service that we provide to the citizens of Pennsylvania and access to justice. We could have a long conversation about fees and how we feel about those, but in this proposal, we're dealing with our reality, which is Act 49 is imperative for us to have it reauthorized.
So when we're talking about fees, can you talk about what the benefits to Pennsylvanians would be if we're shifting the funding for the judiciary away from a fee-based system more towards the general fund?
Well, I think the benefit is one of principle. Frankly, the fees that we are talking about generally are assessed on those that are least capable of paying fees. If for those individuals, it's just an additional tax, and it's somewhat incongruous that those individuals who are paying this increased tax are doing so for access to the justice system. And believe me, we are aware of the necessity for supplementation. There's no question about that. But it strikes really at the heart of the judicial branch when really those who are coming to us through the court system are being assessed an additional tollage, in a sense, for the ability to be there. This is a philosophical question that I am certain that you and your colleagues grapple with on a regular basis, and it's a difficult one. Because money at the end of the day that comes into the coffers is fungible, but where it comes from and what it's used for are really, things that you have to grapple with from a very, very difficult point.
Thank you. Thank you, Justice. Thank you, Chairman.
We thank the gentlelady. Representative Mostello.
Thank you all for being here today. We've talked, I think, for the past 6 days, and I believe every department that's come before us, we've talked about the legalization that the governor has brought forward with the legalization of adult use marijuana and you all are no exception to being asked these questions either, so I know it's going to affect you. And
You're not going to ask me if I'm in favor of it, right?
What's that?
You're not going to ask me if I'm in favor of it.
No,
Okay.
no.
And we don't get a vote either.
Not on the record, no.
Okay.
But yeah, just given his, discussions about this and how he wants to legalize it. And can you tell us, because, his main concern is the overburdening of the courts, whether local, common police level, up to the state levels, obviously. And how much money would the courts be saving if adult use were legalized in Pennsylvania?
I honestly do not know the answer to that question. Because we have such a robust computer system, there may be a way to cull information about the types of infractions and, the toll not only on the system but on the criminal aspect of the justice system. But as I sit here today, I really do not know the answer to that question.
So then along those lines, would it help with reducing the number of cases that are before you? About how many, like an estimate of that?
It's really so, it's really very sui generis to each of the courts of common pleas. And so the statistics would be kept at that level. I really don't know. I mean, frankly, from the Supreme Court level, I just don't actually know how many cases that we have heard in recent vintage deal with those types of infractions. But certainly the impact of anything at that level would be most felt at the county level. Municipal courts, the magisterial districts, and the courts of common pleas.
Okay.
And those statistics, I think, are best found and pulled from those levels.
Okay, great.
Representative, I would add, too, that the counties as well, from a probation and parole management perspective, who are probably supervising some of these people with these charges, whether they're misdemeanors or what have you, certainly decriminalization would have an impact on their caseloads somehow, some way, but they're not within our purview.
Right. And a few days ago, we had heard from the state police that they were not really consulted about this legalization aspect of the marijuana, of what the governor wants to do. And the question I have for you all is, were the courts ever consulted with this? Were you ever brought to the table to discuss this matter?
No, and nor would we be.
Not at all.
Nor would we be. I mean, that is purely an executive and legislative branch decision. The manner in which whatever the statute is plays out, that will ultimately come to us. But in terms of the development of that policy, we just really would not play a role in that.
Okay, great. Thank you so much. Thank you, Mr. Chairman.
Thank the gentlelady. Before we move on, if we could bring the microphones a little bit closer so we can hear everybody. Representative Bellman.
Thank you, Chair, and thank you all for being here. Earlier last year, the Philadelphia delegation had a conversation with some of our judges in Philadelphia, and one thing that they brought up to us was judicial safety. They felt like that they at times received threats, or their family members even received threats from decisions that they made on the court. So Mary Isaacson and I, we introduced a bill, HB 1700, which was later signed into law as Act 89 of 2024, which expanded the definition of endangerment of a public safety official to include federal judges. So my question is, what can we do to help the judiciary and the courts to promote courthouse safety at both the state and the county level?
Thank you, Representative, for that question, and we do appreciate the action that the legislature has taken thus far to ensure not only safety for our judges and court staff, but the people that enter the courthouse doors. In terms of what you could do to continue to help is continue to adequately fund our Unified Judicial System Security line item, which through the AOPC, we use for educational purposes, for assessments of facility and judicial residences, to manage a security incident reporting system. And that is available to judges and court administrators and sheriffs across the Commonwealth so that they can enter in security incidents and we can track where greater security resources are needed, and we can respond to incidents. I can tell you that in 2024, we had nearly 1,000 incidents reported. The other important thing that the UJS security line item covers is grants that flow through our office to the judicial districts so that we can harden and better secure our court facilities at both the magisterial district judge level as well as the trial court level. And what we're asking for in that vein is $3 million for the next fiscal year.
All right, and you said 1,000 instances reported. Were those 1,000 instances that happened in the courtroom, or could they be emails that have come from different places?
All manner of things. Okay. Emails, in-court facilities, threats, via phone, that we work with local law enforcement and state law enforcement to ensure that we're following up and that our judges and court staff are safe.
Awesome. All right, thank you. I appreciate it. Thank you, Chair.
Thank the gentleman. Representative Alsumer.
Thank you, Chairman. Thank you all for being here today. Looking forward to hearing your testimony. My question is around cybersecurity. Your fiscal year end for 2024 through 25 budget included a new $3.49 million appropriation for unified judicial system cybersecurity and disaster recovery. This new appropriation came after a cyber attack targeted the Judiciary network with traffic until it could not respond or crashed, preventing access for users. This budget requests additional funding of nearly $1.2 million, an increase of 33%. Can you explain why you need this increase and what will it fund?
Thank you, Representative, for the question. I mean, I think all branches of our government have experienced the uptick in cybersecurity threats and taking it very seriously. Of course, our denial of service attack that we talked about a little bit in the budget hearing last year has prompted us to take a robust look at our not only our internal controls, but our external controls in terms of service providers, which I won't certainly go into detail here for purposes of security reasons. But your question does give me an opportunity to once again, as we did last year, commend our IT staff, Russell Monchol and his team, for heading off that attack. And no attack is a good attack, but really the denial of service attack is one thing. The ransomware attack is a completely different animal. So since that attack happened and we fended that off, we have engaged, our IT systems department, AOPC, have engaged in a robust look at our vulnerabilities, at what we need for purposes of ensuring that another attack does not happen again, or ensuring an even worse attack does not happen again. My understanding, and I'll certainly defer to our court administrator on where the funds were going, my understanding is the funds are going to go to augment those protections. But I'll defer to our court administrator on that.
Thank you, Justice. That's correct. Via additional personnel that's being assigned to ensure that our statewide case management systems and websites are, because the one website that was attacked was our UJS portal that holds our e-commerce functions as well as our public web docket sheets, amongst a myriad of other functionalities. So additional personnel will be assigned to ensure cybersecurity is maintained, and we intend to go out and bid for a new annual vulnerability and penetration testing of our systems. We've been doing those tests every year for probably 2 decades, but we want to step up and make sure that we are fully wrapped around in our security protections. We are also using the funds to address end-of-life hardware and the infrastructure in our magisterial district courts, as well as in our own data centers.
Since this line in the budget is relatively new, can you update us on how it's operating? are your computer systems safer now than they were a year ago before the funding went into place?
I don't think any of us can rest on we've done enough, but we have certainly, since the DDoS attack, taken every measure possible to ensure that we have a multi-layer defense to protect against a future DDoS attack or a ransomware attack. Quite frankly, Representative, I'm most concerned about the level of cybersecurity in our counties. Many of our counties run the IT functions for our trial courts, and we've had a host of incidents across the Commonwealth that have rendered the functionality of the trial courts inoperable for a period of time due to these types of attacks.
You understand the complexities of cybersecurity and the costs that are just ridiculous in nature. As a small business owner, we bear those, and so I understand the pains that you've gone through. So, thank you very much, Mr. Chairman. Thank you.
Thank the gentleman. Representative Malagari.
Thank you, Mr. Chairman. To our justices, thank you so much for being here. In 2022, the Administrative Office of Pennsylvania Courts created a task force focused on issues affecting justice-involved individuals with autism and intellectual disabilities. Can you tell me more about this task force? Additionally, what they found and how the judiciary has acted upon their finding to make justice available for all Pennsylvanians?
I'd be pleased to do that because the Autisms in the Court program is something that the court is very proud of. I will give a call out to our colleague, Justice Kevin Doherty, who's from the Philadelphia area, who was a common pleas court judge there for many years, and tell briefly his story, which that he would see someone come into his courtroom and find a young man out of control, and he had no idea how to deal with him, and he was embarrassed greatly to find that it was a child who was actually impacted by autism. And that struck him to such a point that he decided that on a statewide basis, each of our courts should look at this issue and be certain that we aren't missing people who come through the system who should be treated in a special manner, not a different manner, but in a manner that's attendant to their disability. And it's been quite successful. It's been embraced by the Courts of Common Pleas and by the Departments of Human Services in each of those counties. Many courtrooms have developed quiet rooms, which are a great solace to individuals who suffer anywhere on the autism disorder. And I think it is fair to say that the roundtables that have taken place through that task force have resulted in substantial beneficial changes within the Court of Common Pleas. And we're very proud of that as a court.
I appreciate hearing that. It's a really important part of our society to understand those with differences in ability and also different avenues of autism or intellectual disability that they have, and it's really important that we continue to strive for awareness, but also in every aspect of life, including the justice system, that we're prepared to interact and also hopefully provide justice for those individuals as well with empathy in mind. So I appreciate your work in that. Thank you, Mr. Chairman.
Well, thank you.
Thank the gentleman. Representative Brown.
Thank you, Chairman, and thank you, Justices, for being here with us today. One of our most vulnerable populations is our senior community, and it's one that I'm most protective of. So in looking over your budget, one of the increases that actually caught my attention was for the Office of Elder Justice in the courts. It increases by 51%. Could you tell us about the important work that's being done in this office and why it needs such a large percentage increase?
Yes, and actually, that increase is a result of the end of federal funding that was provided for 3 staff members within that office. And so these are essentially straight out personnel costs so that the office and these individuals can continue in their educational efforts at multiple levels. I'll give you an example. You're aware of the guardianship tracking system that we have in Pennsylvania, and although that is geared toward all individuals who need guardians, it is primarily a function of making certain that the elder population is treated with respect and dignity when they go through the court system. Individuals who work through this personnel increase are involved with training common pleas court judges, their staff members, and other individuals in the system on how to use that guardianship tracking system, which I might add is a national example now. And once again, our computer system in the judicial branch did a fabulous job of developing from scratch that program. So individuals like this are necessary and have been from the genesis to make certain that people who are working with that tracking system know how to do it. It's also an educational tool in general. The access to all of the information and help that's out there for the elderly is really not necessarily well known. And so this is an educational effort in that respect. So this is in order to continue the good work that the Elder Law Task Force has been doing.
I'm glad to hear it. If I could pivot quickly, I interact with my local justices quite a bit. And one of them came to me because we had a YDC in our area, a youth detention center that was shut down, as were most of them, if not all of them, across the state. And he said that he has a big problem now in knowing what to do with juveniles who come through the court systems. In fact, he had one that came through that brought a knife to school, and because he had nowhere to send him, he had to send him back home to his parents. So I'm wondering, what are some of the repercussions that you all are feeling because of these systems being shut down? And what are we doing with our juvenile population that has this need?
Well, what are we doing with them? The courts, we get them at the wrong point, obviously, because when they come into the court system, something has gone awry in their life, and they're brought, to the common police court level or the municipal court level to deal with a problem that was generated outside of anything we've actually had control over. Once kids are in the justice system, the manner in which they're treated in the juvenile courts is with care. I mean, a child like that is probably in a situation where there is a lack of oversight on part of the family members. And so once we're there, we can, intercede. But what to do with them after that fact?
So you have nowhere to send them virtually.
Well, I think, Representative, it's a combination of it's a local issue with these county centers that have been closed, and I too have heard from some of my colleagues on the Common Pleas bench these placement decisions are much harder, particularly in the counties where some of these juvenile facilities have been closed. That's certainly a concern for us, and it's a concern for our judges at the Common Pleas Court level. My hope is that those common police court judges that are experiencing those are empowered, have good relationships with their county commissioners to find solutions to these problems. I personally am not a fan of housing these juveniles with adult offenders. I think that's certainly
which is what we're having to do. And in fact, we're taking some from other counties because we have room, but it's very scary to me. So
there are some counties, and to interrupt you respectfully, there are some counties that are transporting their juveniles much farther than they should have to. Taking these juveniles away from their families and their support systems is not a good system.
It's just something to consider for the future budget. Thanks.
Thank the gentlelady. Representative Gallagher.
Thank you, Chairman. Good afternoon, Justices. The governor's budget calls for expungement of records for those incarcerated for only possession-related offenses attributed to cannabis. I understand that we have not seen the final legislation at this point, but given the APOC's role in the clean slate effort, what role would you imagine APOC playing in this process?
I can expect we're going to have to play a role because it's another layer of clean slate. I mean, we as the AOPC and the Supreme Court, we're certainly committed to implementing the legislation that we have to implement from a perspective of the clean slate records and working with the Pennsylvania State Police on all of those efforts. There's a technological toll to that. To the extent the expungement becomes a law or an initiative passed by the General Assembly and signed by the governor, we certainly would hope that there'd be some consideration to the additional costs that the judicial branch will have to absorb, and the state police, for that matter, would have to absorb for purposes of implementing that. We were able to do that from the clean slate perspective. It did come at a price, and not a price that we had to come back for some sort of a supplemental appropriation, but the price was other things that were on our sort of IT agenda sort of had to be put on hold for a period of time. But we are prepared, and we certainly have experience with our IT team working with the Pennsylvania State Police that we could implement something. We just ask that some consideration be given in the legislation of both expense and time. Give us enough lead time to work the systems out and make sure we can implement it in a way that makes sense and follows the will of the General Assembly.
Thank you, Justice. I appreciate it. Thanks for your time.
Thank the gentleman. Representative Krupa.
Thank you, Mr. Chair. I want to follow up. Thank you all for being here for your testimony today. I want to follow up on the line of questioning by my friend and colleague, Representative Mastella, regarding the impact of adult use recreational marijuana. And I understand completely that you can't comment on whether you think it should be legalized. I personally think it's a terrible idea. I think it's very naive and reckless not to do an independent consideration of the cost-benefit analysis, and that it's really going to be detrimental to our society. But that being said, it is appropriate for you all to answer questions regarding the burden or impact that this may have on our judiciary. With respect to the caseload, it's interesting to me that the discussion is on the proposed decrease in the litigation regarding possession of a small amount of marijuana. But if you look at other states that have already legalized it, you're seeing an increase in things such as crime, traffic accidents, DUIs. So what do you genuinely anticipate that it's going to do to the caseload across Pennsylvania if adult use marijuana is legalized?
Representative genuinely anticipates suggests that I've anticipated anything, genuinely or ingenuinely or disingenuously. I think the problem we're having articulating an answer to the question is, as judges, we just don't think like that. Our common pleas court judges and our municipal court judges are not at a loss of work. And they don't think in terms of, well, if this legislation passes, all of a sudden my docket is going to go down 20 or 30%. There may be statistics out there to support that, and AOPC may have them, but my, space abhors a vacuum, and I just assume that if all the small amount of marijuana personal use goes away, we're not going to really notice it personally, because that's not how judges look at their dockets.
Well, let me ask it a little bit of a different way. Given that there's no widely accepted roadside tests for marijuana impairment, do you anticipate that the amount of cases, omnibus pretrial motions to suppress regarding whether there's a lab drawn taken or not taken, and it's just visual impairments, in your expert opinion, do you think that there's going to be an increase in that type of litigation?
That's the first time anybody's thought of me as an expert in anything. Respectfully, I don't think we can answer that question because, again, it's just not a way. I think law enforcement might be able to answer that question. What would be the burden of something like that on the state police or local municipal police in terms of testing and suppression hearings and things like that? But again, judges just kind of don't look at it that way.
You just deal with what's on your on the table on the docket of the day.
Yeah.
Okay. So there's been a lot of conversation about the expungement, and the government's proposing an immediate expungement of the records of those incarcerated. Now, I think we need to be mindful of the fact that there's a difference between expungement and pardon. So what are we going to do with any individual that may, and although I do think at this point in the game that it's probably going to be rare, but in the instance that you may have somebody that is currently incarcerated, maybe because of a past record record score, but that is currently actually physically incarcerated because of possession of a small amount of marijuana. So you're not talking about expungement at that point. You're going to have to talk about a pardon. Has there been any discussion about that?
We have not discussed any aspect of this, frankly. This is, this is something that's in the formative stages at your level, and we really don't have any tendency to review these issues until, frankly, they come up to us. So we haven't thought about that at all.
Okay. Do you anticipate, with respect to child custody and welfare cases, how legalizing would impact custody disputes where one parent is using marijuana recreationally? And I know, so I'm from Southern Fayette County. In a past life, I did do some family law. So, I mean, and that was obviously an issue. If you had a parent that couldn't pass a drug test. So are you anticipating that the courts are going to need to develop new standards to determine when use is problematic?
I honestly don't think so, as you know, because you're familiar with this area. The courts are going to look at what's in the best interest of the child, and they will take evidence on all aspects of the issue as you've prevented it. So there wouldn't be a new test. It would be the same test, best interest of the child.
With respect to landlord-tenant disputes, if marijuana is legalized, would the court see an increase in landlord-tenant disputes over marijuana use in rental properties, especially where federal housing assistance is involved, because we all know that it has not been legalized on the federal level?
Representative, again, this is something that I'm not sure we have really even thought. Actually, I won't even say not sure. We haven't thought about it. I think it's fair to say, if I can have this agreement with you, certainly there will be a lot of collateral consequences to legalizing adult use recreational marijuana. And I am very confident that the General Assembly and the governor are going to be able to talk about those collateral consequences and reach some sort of agreement on or not. But we deal with collateral consequences when they're presented to us, and we just haven't dealt with these hypotheticals.
Well, I see that I'm out of time. I have a lot more questions, but thank you all for your testimony today.
Thank you.
Thank the gentlelady. Representative Fleming.
Thank you, Chairman. Good afternoon, Justices. Thank you so much for being with us. The first treatment court in Pennsylvania opened in Philadelphia in 1997 as an adult drug court program. Since then, the treatment court movement in the Commonwealth has expanded to include driving under the influence, DUI courts, mental health courts, and veterans courts, all of which I'm proud to say we have here in Dauphin County. Can you elaborate on some of the successes of treatment courts or alternative courts in your experience and estimation?
Well, if there are people that are hearing this that have never gone to a treatment court graduation, whether it's a mental health court, a DUI court, a veterans court, I encourage them to do that, because our judges and our treatment court administrators throughout the Commonwealth of Pennsylvania and our 138 or 139 that we know of treatment courts in Pennsylvania are doing a tremendous job at really changing and in many respects saving lives. The Supreme Court is all invested on these treatment court initiatives. They give people an opportunity to avoid jail time and a lot of collateral consequences that come from that. Helping them secure treatment for addiction, helping them secure housing, helping them secure jobs and healthcare, and celebrating what we might sometimes take for granted as real accomplishments in their lives and turning around their lives. So I believe that the treatment courts have been very effective. We just opened, or we just established our regional veterans treatment court recently. In Blair Center, Clearfield, Clinton, Huntington, Juniata, boys, I got to breathe, Mifflin and Perry counties, fully operational with President Judge Wade Kegerais in Blair and Judge Salisbury in Clinton County. They're presiding over that right now. Again, we're changing lives there. There's more that we can do, which is why the court is looking at this year at rolling out a certification program through the national certification organization it's now called All Rise. They are finishing up their modules. We plan to roll out our first level of certification hopefully by the end of the year and really start it in earnest next year. But we are fully invested in these treatment courts, and I have seen personally, having attended just recently a treatment court up in Luzerne County, the remarkable work that these judges and these people are doing to change these lives.
That's incredible, and I just want to say, anything that we can do. I have heard, I wanted to get your opinion on it. Locally, they have been a success here in Dauphin County. We've been able to, like you said, change lives, keep people out of our judicial system that really deserve that helping hand, so to speak, rather than just to sit in jail. If there's anything more the General Assembly can do to enhance these, and your number 139, it's not lost on me, that's multiple courts per county, so that's a really good thing. So if there's any more that we can do to help expand this and really keep this movement going, please, I'm happy to be a part of that, and don't hesitate to reach out to us, okay?
Thank you.
Thank you so much, Justices. Thank you, Chairman.
Thank you, gentlemen. Representative Kale.
Thank you, Mr. Chairman. Justices, I feel like I should be opening up by saying, may it please the court. Thank you.
We're in your house.
I'm putting on my legislator's hat. Thank you. Thank you for being here today. I truly do appreciate it. Going through some of the line items that you guys have in your budget, one of them was a blast from the past for me. The Integrated Criminal Justice System, JNET. As a law clerk for Judge Kunselman back when she was a Beaver County Common Pleas judge, I remember going through the system and using the system and helping it assist us. And I'm seeing that there is an increase of $1 million, which is about a 40% increase. And I know it's a very important system. I'm just curious, what is that $1 million increase going to be used for?
That's the actual cost of continuing to operate JNET.
So that's
the actual cost involved with the continuation of the operation of the JNET system.
In years past, we haven't been covering the costs for it?
Yeah, and I'll ask, again, this is why we have the court administrator here to correct what we're saying. We have found a way to keep JNET operational under the prior appropriation, but it has come at a cost. And in this year's budget, we decided, we thought it was best to come to the General Assembly and say, no, this is what it costs to operate this vital system, the system that Representative, that you acknowledge is so vital, not only to our courts, but also our law enforcement. So we wanted to put the actual cost on paper so you saw what it was. And there has been a toll to not fully funding it on that line item. So I'll defer to the court administrator.
Previously, we split the funding between the Judicial Computer System Augmentation Account and then this relatively new line item. And so again, as the justices have mentioned, we are coming to you to ask for full funding through this line item to participate in JNET.
Well, I'm glad to see that hopefully it will be fully funded this year. It is a very important program, and I'm happy to hear that that's what you'll be using that for. I want to transition to another question. There's been a lot of discussion amongst this body over the course of the last number of years since I've been here regarding a new way of selecting justices to the state Supreme Court. It's called merit-based selection. There was a constitutional amendment proposed a number of years ago. It didn't go anywhere. It didn't end up happening, but it's been a conversation ever since. And it wouldn't affect any justices that are currently on the court, obviously. But I am curious, as justices that have been through the process, have been through the system, and I personally am not sure where I land on this issue yet. Either way, I've gone back and forth. I'm curious if you have an opinion on that, and if you can inform the legislature of your thoughts on a system like that.
Well, I can tell you my educated opinion since I've been a candidate for the Superior Court and then the Supreme Court. So one thing I can tell you for certain is that it appears as though the citizens that I meet like to elect their judges because they like to meet the people who will be serving on the courts in Pennsylvania. You know, there was a full-hearted attempt to change the Constitution to provide for merit selection back in 1968, and the effort lost by 28,000 votes. It was a very, 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 very narrow vote. So the discussions that you're having have been going on. Actually, the first time the discussion took place, if my recollection serves me, was in 1952. So this notion of whether or not to elect judges or politically select judges has been an ongoing point of some consternation, some argument, some concern. And I can tell you that from my experience serving on 2 appellate courts in Pennsylvania with judges and justices have been elected, the citizens have done a fine job of electing judges and justices with merit. Would it happen otherwise? Maybe. But it's a discussion that will probably not end in this cycle. There's a lot of comparison. Look at the federal system, which is a politically selected judiciary, and look at our system. You know, there are contrasts. There are all kinds of things that you look at. But you asked my opinion. I think the citizens have done pretty well with the judges and justices that I've served with.
Thank you. Thank you, Mr. Chairman. Thank you, Justices.
Thank the gentleman. Representative Khan.
Thank you, Mr. Chairman. Thank you, Justice Brobson and Justice Donahue. We're very proud of our Supreme Court in Pennsylvania, and thank you for your service. So I'm a healthcare provider. I'm a nurse practitioner, and I know as a nurse practitioner that substance use is a healthcare issue. It's a clinical issue, not necessarily something for the criminal justice system. If there's no crime that's committed. And I'm working on a bill with Representative Flick, a bipartisan bill, to encourage the use of peer support services for recovery, to encourage recovery, so that we can help get people off of substance use. Obviously, it's an epidemic in Pennsylvania, as it is across the world, and we need to take actions to combat this epidemic. So my question is about our drug courts in Pennsylvania. And first of all, are we utilizing our drug courts appropriately? Is there a chance to expand them? Is there a need to expand them, to use them more than the traditional court system? I'm also wondering, too, since it is really a great tool that we have, there's a great infrastructure of support. I've talked to people who have been in and have gone through drug court that have said the immense support. I've heard about the hand-holding that they have to get them to the next step so that they can become substance-free. And I'm wondering, is there something that we could consider where people could get sort of that infrastructure but not actually have to get a criminal conviction to go through it? Is it something that maybe we could think about? And just wondering if it's something that we're using efficiently, or are there other ways that we can encourage diversion so that people with substance use disorder don't end up being in prison or jail? Thank you.
Thank you, Representative. As you may have understood from my response to my question to Representative Fleming, I am an unabashed fan of what our judges and our treatment court administrators are doing throughout the Commonwealth of Pennsylvania, particularly in our drug courts. You know, just sending many of these people to jail doesn't ensure that they're not going to reoffend if they're not getting the treatment that they need. I'm still educating myself on this process. It's a constant education. There are common police court judges in our state that know this area a lot more than I do, so I'm still coming up to speed. I know that you raised certified peer specialists. I know that that is something that the trial judges are very interested in having involved in the drug treatment courts. I think some of them do have them involved. But if you actually go to some drug treatment courts, DUI courts, or particularly our Veterans Court, the idea of mentorship is a very strong aspect of our treatment court model. You know, so we want to expand drug courts. We want our drug courts, our DUI courts, our Veterans courts to employ best practices, which is why the Supreme Court is investing in the certification process across the state, why we're encouraging courts that don't have them to create drug DUI treatment courts, finding opportunities to partner with other counties. Let's say their population is not as strong, but partner with other counties and share resources on the wraparound services that these people need, whether it's treatment, healthcare, jobs, transportation, little things that will help them not relapse and to stay away from their addictions. So we're working hard with that. Angela Lowry is doing a fantastic job in our AOPC team, heading our treatment court program. And we're not done. We're hoping to I'm hoping to be able to come back here next year and tell you more great stories about what we're doing. In terms of what we can do to get them before they go into the justice system, I certainly think that's valuable. I don't know that we can do anything about that, But I think that to the extent that the General Assembly, in partnership with the governor, can come up with ideas, partnership with our county commissioners, partnership with our local health care providers, can come up for ways to identify these people with addiction early, so they're, who are at risk of engaging in criminal offenses, and interdict early. I don't think you'll find anybody in the judiciary that's against that.
Thank you, Chairman. Thank you, Justices. Appreciate it. Thank you.
Thank you, gentlemen. Representative Kutz.
Thank you, Chairman. Good afternoon, Justices. Thank you so much for being here. I have a couple of questions. I want to first start following up on a question I asked last year. I don't think we had a resolution to it that we came to, so I think you know where I'm going, or at least Justice Probson, I think you do. The bar exam. So the July administration.
You passed, Representative. You passed.
I did. Thank you. Thank you.
Give it up.
I know you were there. It was great. Beautiful pictures. So I have two concerns, and I asked about sites before. July is Philadelphia and Pittsburgh. I believe February is Lancaster and Pittsburgh. I'd love to have a site in the mid-state. I think there's a lot of population there that's underserved, and the reason I say that is I think it becomes cost prohibitive when your early application fee is $650, your final one is $1,500. If you add 2 nights in a hotel in Philadelphia, downtown Philadelphia, on top of that, to within walking distance of the convention center, it really gets up there in terms of cost. It cost me over $1,200 to take the bar exam. My concern is also for individuals who are then going into public service, whether it be a public defender or DA's office. They're not going into a private sector law job with a higher starting salary, so these costs can be prohibitive. Curious if there's any thoughts as to either the fee structure for the exam, and again, I know with convention center rental, that fee's probably got to be high enough to pay for the cost of the exam, which is uniform across whatever professional license you're seeking. But are there thoughts to additional sites to perhaps ease the burden so not every student has to travel 2 hours? And I would add pay turnpike tolls, which probably cost more than a hotel room, and then 2 nights in a hotel on top of that. Just curious for your thoughts.
Let me try. Since I wasn't here last year to hear Justice Robson's response to it. Part of the issue involved with the cost of the bar exam is really facility rental. So, one of the ways to keep the cost somewhat controlled is to not rent additional facilities. Now, let me back off from that just a little bit, because I understand what your concern is. Where the sites are held now are generally located in locations where there's a large law student population. Philadelphia and Pittsburgh, multiple law schools in both locations. But you would say to me, we have that also in the central part of the state. And so maybe Justice Robson said this to you last year, but from my perspective, I'd like to ask the Board of Law Examiners what the possibility is of having a location that's more central to the law schools that you have located in central Pennsylvania, if the driver is the location of students who are coming from law schools on the east and west part of the state. I think it's a legitimate question.
And I'll augment my answer from last year, because I Representative, being from the central part of the state, I completely understand this. I took my bar examination over at the Holiday Inn that used to be Wanda's on the West Shore.
It's about to become a BJ's.
Yeah, that's going to be a BJ's wholesale store, but I took it over there, took the test, hopped in the car, and drove to New Jersey to take the New Jersey bar examination the next day. I understand that challenge and particularly understand the cost. We're always very conscious of the fees associated with taking the bar examination. A lot of the fees aren't things that we can control.
Understood.
In terms of the location, I have inquired to our Board of Bar Examinations about why we're doing it the way that we're doing it. One of the reasons why we're doing it is finding a facility in central Pennsylvania that not only is cost effective, but can accommodate all of the security and the IT issues that have to be handled when it comes to taking the bar examination, as you probably are aware, pretty much the exam is online, or is going to be going online at this
and
point.
you can't have a place where the computers all crash when you got 12.
And we all know that the internet is not reliable outside of Philadelphia and Pittsburgh. So I mean, especially on the Turnpike. But these are things that they're constantly looking for in terms of facilities. The facilities that we use in Pittsburgh and Philadelphia have been tested, secure. It's providing that. As we go forward, I can represent to you that the Board of Bar Examinations is very aware of the desire to have a central Pennsylvania facility. They have it once a cycle, but I will be continuing to raise it as we continue to move down this road. That's not going to be the end of our bar examination discussions.
No,
We're going to have more
I appreciate that. I had another question. I will wrap up instead with a point, given the time's about to expire. One thing I just want to plug for, I'm concerned, our MDJ offices, security-wise, as well as I do, a lot of these are in strip malls. You have victims and perpetrators that or alleged perpetrators that are often in close proximity. Judges have security concerns as well. I know you can add things like bulletproof glass, but that may not always be effective to getting people and keeping them from entering through the lobby. So if I had more time, I would ask potential measures that we could take to beef up security for magistrate or district judge offices.
If I could have more time to answer you, to the court administrator about fully funding our appropriation for our county grant money to grant for security. But also the counties are really the ones that are responsible for providing that space and providing that security too. So to the extent working with the county commissioners and getting them more funding, that would be helpful as well.
Excellent.
Chairman, I will give you credit. That was fairly creative. That was fairly creative. Got my eye on you. All right. Representative Friel.
I appreciate your time here today. I'm going to get right to it, and I'm going to dive a little deeper into the treatment courts. We had the Attorney General here earlier, and he brought up the cost of mental health in both from our police, in my own local police force, where we're losing hospital space to be able to take folks to mental health treatment facilities. They're ending up in our judicial system and being incarcerated. So do you have an idea of how many mental health district courts are out in Pennsylvania? And do you have an idea of, do we resource these courts? Do we have enough, and do we have enough resources on the mental health, given the increase in mental health crisis in PA, to deal with those challenges?
So as our court administrator is looking to see if we have the breakdown of the 138 that we know of, how many of those are mental health courts, I'll say to this, no, we don't have enough resources. We're doing, and our courts are doing the best they can with the resources that are given to us. And they're being creative. A lot of our treatment courts are operating off of grant money. Some of the services that they're providing to their clients that come before them are being provided gratis, voluntarily by people. Their spare time, whether it's a local mental health care provider that is making their facilities available. A lot of this is being done, I don't want to say with Band-Aids and bubble gum, but because we're certainly grateful for all the support that we have gotten. But as long as I am sitting in this chair, I will continue to advocate for more funding for our treatment courts annually and annually. Again, the goal of this budget was to kind of get us again just to where we need to be to operate the courts generally. My hope is to be able to come back and say, now this is what we need to operate generally. We want to go even more on treatment courts. We need your help. We want to increase this line item by X%, and this is what we want to do with it. So I'm completely with you on that, and no, we don't have enough, but again, I give credit to all of our judges, all of our treatment court staff that are out there, that are probation and parole people that are out there really investing their heart and their spare time in helping these people that deserve the help.
No, I appreciate that, and this would be somewhat a rhetorical question, is on the mental health front, I would think it would be more cost-effective for the state to put expertise in place at the front end of when we're doing, picking someone up with by the police, hitting that court system with a treatment court, versus incarceration and dealing it within the prison system and the financial burdens there. So I would hope that you would think it would be a good investment and probably a better use of taxpayer dollars to invest in our court system and on the front end of it than on the back end.
Absolutely.
Absolutely.
I appreciate that, Chairman.
Yes, I'd like to answer your question,
Please.
if I might. We have 30 adult mental health courts and 1 juvenile in operation in the Commonwealth right now.
Just one juvenile. And that feels like an area we could expand.
If I might supplement, the AOPC in the last year started a behavioral health initiative. It grew out of a national task force series of recommendations coming from the Conference of Chief Justices and State Court Administrators that courts and communities need to do more to respond to the behavioral health crisis in our nation. So we have devoted a small but mighty staff of 2. We had a statewide summit last fall with over 500 participants, courts, county commissioners, service providers, coming together, 51 county-based action teams to identify where the gaps in addressing this crisis are and come up with practical steps that they can take in their communities to address, including not the courts, but the county governments in upstream, what they call upstream, getting to these individuals that need services and supports before they enter the criminal justice system. Because it's not just the criminal justice system, it's our family courts, it's our magisterial district courts. So we need to address this.
Thank you very much, and I'd be very interested if you had the findings of that, if you could send it to the chairman there. And since I am not clever enough and didn't pass the bar to extend it like my friend, I'm going to yield the rest. Thank you, sir.
Thank the gentleman. Representative Nelson.
Thank you, Mr. Chair. I would suggest it was a benefit that you avoided the bar, right? And we said we're able to be there. So, yes, thank you for being here today. And really, our questions from my colleague from across the aisle dovetail very nicely. I agree. It would be nice to see more priority for upstream mental health prevention in the budget. Yet again, we don't really see that level of commitment. But I do really support, I think we all support the specialty treatment courts, the veterans courts, the drug courts. The drug courts have been one of the most successful. I'm in Westmoreland County. Our judges run those courts at lunch. Everybody's doing it on other time, and we have some of the best, sustained recovery rates. And I attend those graduations. I see those people working in the community, getting their kids back. It's a great thing. But not everybody gets into those courts. And so in your comments, on the second page, there were remarks, judicial efficiency, one of those responsibilities, making sure judicial resources are utilized where the workload dictates, with that eye to controlling costs. In Westmoreland County, in our prisons, we've had a recurring multi-year issue with backlog because of the delay in evaluations, mental health evaluations, competency, even in forensics beds. We had a really large gathering. It wasn't 500 people. It was a full packed room of providers, judges, Senate representatives. And it's gotten a little bit better, but we're just an example, and this is our small Westmoreland County, but it could be 60 days oftentimes to get scheduled, 3 weeks to get the report, and then another 60 days for females, 30 days for males to actually get a transfer into Torrance. So our folks that are really dedicated in that system are saying it's about 6 months from date of incorporation to date of appropriate placement. And that's really putting an enormous strain on both our prison guards, our correction officers, the system itself, and oftentimes these individuals they're not receiving medications or treatment. As we prioritize, I think we agree on both sides that less time in prison is better for everyone. Can you touch on ways that we might be able to improve efficiency in this area, or how we could better apply resources to target this backlog?
One of the features of the summit, Representative, was a full panel from Montgomery County, including representation from Norristown and Torrance State Hospitals, on the importance of establishing competency dockets so that there is not this lag time to evaluate a individual's competency and see whether, they can get restored. I know that that is a measure that we're looking at, several other judicial districts are now looking at as a result of the summit to implement. I think that is one measure. This is a very large, complex issue that I just think we need to keep working at.
And are there dollars in this budget? I mean, I haven't seen any. And Justice, you hit it right on the head. There are grants that are out there for this, but like, as we prioritize taxpayer dollars to have less taxpayers in prison, 6 months in prison just to get where you need to be, like, would there be an opportunity, or would the judiciary support an opportunity to increase funding for forensic beds and evaluations? Because,
Yeah, the answer to your first question is we don't have anything on our budget to do those things. That's not within our purview. I mean, if you were to tell me that there's something going on in our common pleas courts that the backlog is there, then that's something we can do about. I think it's resourcing, to your point. I think that's really where the struggle is. So that's county level, that's county services, that's our hospitals and our health systems, that's the beds, what kind of beds are available, who's paying for the beds. Again, I'll go out on a limb here and say I don't think you're going to find anybody up here that doesn't think investing in those things is a good thing. Even from an access to justice perspective, having people that are weighting competency determinations, a judge can't make those determinations on his or her own. We're waiting for the professional evaluation to have those evaluations done. So anything that can be done to speed them up so people who are in prison shouldn't be in prison as long as they are, I don't think you're going to find anybody up here that opposes that.
And as you know, the judges on the Court of Common Pleas of your county are hardworking. They are very efficient, and I would venture a strong statement that that is not what the holdup is, because they are among the best in the state. So the issue doesn't really lie with our judges or our budget. It is a different issue that desperately needs to be addressed for all of the reasons that you've just stated.
Thank you. Yes, I agree completely with that sentiment.
Mm-hmm.
We have some great judges, good-looking judges too, I have to say too. So thank you, Mr. Chair. Appreciate it.
I just want to let the gentleman know that you didn't go to law school, but you did go over your time, just like the gentleman. Just saying.
Thank you.
Representative Eckert.
Thank you, Mr. Chairman, and thank you guys for being here. Thank you, Justices, and I really appreciate the opportunity to ask you some questions. I want to get into the Rules Committee, and I see there's an appropriation for about $1.5 million for that committee. I'm just curious, what's the role of the Rules Committee as far as when obviously separation of powers, the court has autonomy over its rules. What is that appropriation used for as it pertains to making those decisions?
Well, we have multiple rules committees, as you know, and we have a criminal rules committee, civil orphans court. We have committees that report to us on evidentiary issues and things of that nature. They are really central to the functioning of the way that our court proceeds. And oftentimes, as a result of legislation, there are rule changes that are required, which require study and review and writing. So we have committees that are made up of people who are appointed by the court, generally speaking lawyers. We also have internal staff who spends countless hours working through all of the variations that are needed to bring the rules of procedure up to new statutes, or problems that we find with the rules just because of the way they're operating, within the system. So the staffing that's required for that is part of that amount, and the committee functioning, which is more minimal. They probably meet 6 times a year, and that is all voluntary. All of our lawyers who serve on those committees give countless hours of their time to assist us in that process. But the funding that you're looking at is for the personnel that's required in order to keep that process moving. And I'm going to venture a guess. I mean, it's close. We probably have 14 or 15 different committees and boards that report to us on the various obligations that we have as the Supreme Court.
So obviously, you know, when we pass a law and there's regulatory rules and things that goes through a regulatory process, obviously the court's in a different realm. But there's public comment, there's all kinds of, you know, checks and balances there as far as when rules are promulgated. How does that work on your end? I mean, do you solicit public comment? Do you allow people to provide input when you're reviewing rules? Like, how does that work? What's the process there, right? Because I think even though that, you know, the courts obviously have autonomy over their own rules, I think public input is good in those situations. Do you solicit that kind of information?
Very much the same way that you do. All of our rule proposals go out for at least a 30-day public comment period. When those comments are returned, they return to the committee who digests them. They will sometimes make a revision just based upon the strength of public comment that comes in before they send it to us for ultimate review. We will oftentimes see a rule proposal, send it back to the committee, and tell them to do another public comment route on it because of changes that we are recommending to them. So our rules are not just generated by handpicked people that, you know, we have chosen and then comes to us. It really is a process that looks somewhat similar to the manner in which you proceed with your regulations.
And Madam Justice, when you talk about us, you mean the collective of the Supreme Court, because at the end of the day,
Correct.
yeah.
Correct. Yes.
Okay.
Yes. Yeah.
And how does that work with existing rules that are still under review? I mean, do you still follow that same process?
Well, if we have an existing rule, we would not do anything with it unless there was a proposal for change. That may come from the public, and that proposal for change of an existing rule could be made to the committee, who would then undertake a revision or ask us if we want them to look at it. But unless and until there is input from somewhere that something needs to happen with an existing rule, it will remain status quo.
But it follows the same process,
Exactly.
right? If it's a proposal that someone,
Exactly.
same process after the fact.
Exactly.
Real quick, obviously, the governor has, in his different agencies, has looked at cost savings, he called it the remap, but is there, and looking at how to be more efficiencies and how to spend government money better, have you guys looked in-house of how you guys can save money and certain ways to use taxpayer money in a more efficient manner?
Yes, we always do. I mean, we operated very, very leanly, as you know, for many years. I mean, we didn't have an increase in our budget. So given that fact, we were forced to really get to bare bones on most things. But on an ongoing basis, and I'll just mention it again because it's something that once again comes back to things that the public comment on. When the magistrate districts are realigned, that ultimately can result in the elimination of a district. None of that happens without significant and deep public comment, and honestly, that's one area where we probably see the most input, because that's the level of the judiciary that most impacts on a daily basis, you know, the people within those magisterial districts. But a realignment can result in an elimination of a district, which is a cost savings. Not one that's done for the purpose of saving costs, but it's to make certain that we're running efficiently. We did the same thing with the senior judge utilization over the years. And so we decreased the number of hours that senior judges can be used at the courts of common pleas level. So we're constantly looking at the moving parts that we have. But I can say with some confidence that, you know, we keep our eye on that, and there isn't anything to any of us that's an obvious area that needs immediate kinds of attention like that.
Thank you, Madam Justice. Thank you. Thank you, Mr. Chairman. Thanks for giving me that indulgence.
Thank the gentleman.
For a second round, Representative Kincaid.
Thank you, Mr. Chairman. I couldn't stay away. I wanted to talk about the CJEs. Obviously, continuing judicial education is relatively new. And I think it's pretty well known that there is a bias within the justice system when it comes to sentencing. There's a racial disparity, there's a gender disparity. And I'm wondering if you guys can talk about how CJEs are being used or other programming to educate our judges about implicit biases and other issues to be able to address those kinds of things.
Well, we, on a regular basis, have obviously seminars that deal with multiple issues. I'm trying to recall how frequently we do bias sensitivity training, but certainly within the last 2 or 3 years, there have been a number of programs that have been offered at that level. And, so it's something that we are all aware of and sensitive to, and our common police court judges are fully participatory in our continuing judicial education programs. And I might add, we as Supreme Court justices also have continuing judicial education obligations, which is not the case in many states that have judicial education requirements. So it's certainly an issue that's been on our radar over the years, as it has been. It's true within our continuing legal education system also. Our CLE board is very active in training on bias sensitivities.
Thank you. And I want to shift gears to talk about juveniles. We've had a number of conversations about it, but one of the biggest issues when it comes to juvenile justice is direct filing and decertification from adult court to juvenile court. And I've had a number of conversations with juveniles who are incarcerated in our county jails who have been detained for a year or more just waiting for decertification that's basically been agreed to. What can the courts be doing to ensure that we are moving that process along faster to not detain these juveniles in adult facilities while they're waiting for decertification?
Well, I think it's a cooperative issue. Since I've been on the court and been exposed to this area, we have issued several opinions dealing with, I think of the opinions that we've dealt with so far dealing with the aged out defendants and what that means. And I think your timing question goes to that to a certain extent. Timing is critical, and that's why that process is supposed to move very quickly. I think our judges do, generally speaking. I haven't heard an anecdotal example where a judge hasn't been moving as quickly as possible with those processes as they can. So again, where the gum up is in the system, if there is a gum up, we would like to know. If the gum up is on the court side, we certainly would like to try to fix it. But there's the criminal dockets are complex. The funding for the district attorney's office, the funding for the public defenders, the services, sometimes the mental health services, the evaluations we talked about earlier that have to be done in some of these decertification matters are complicated. I think our rules are designed to make them go quick. But as Judge Potter Stewart once said, swift justice demands more than just swiftness, and we have to get it right. But certainly we don't, again, like the idea of juveniles languishing in adult facilities or prisons. If in fact they are a proper candidate for decertification, we would like to get our judges in a position where they can respond to those matters quickly.
Thank you. So basically, I think the sort of running theme is that as the legislature, we need to be stepping up and providing more resources to ensure that these kind of processes can go a little bit faster, whether it's mental health evaluations or any number of things. Would that be fair to say?
If you said it, it must be fair. Whether I certainly don't want to get into the prerogative of what the legislature should fund and shouldn't fund, other than to make the ask that we have made in our budget proposal. But we know, we have a commitment as a court juvenile justice issues. We're aware of the importance of these decertifications of direct file cases. I've encountered them. In terms of the process, the juvenile court system exists as a creature of the General Assembly, not as a creature of the courts. So whatever adjustments have to be made, I think have to be made legislatively.
Thank you. Thank you, Mr. Chairman.
Thank the gentlelady, Representative Krupa, for the second time.
Thank you, Mr. Chair. In addition to the general fund appropriations that fund your operations, another major source of funding comes from court fees, what are known as Act 49 of 2009, as well as other fees that fund the unified judicial system. Recently, this fee revenue has been on a downward trend. Do you expect that trend will continue?
We don't know, and I think that's the problem, is we have seen years where we have, especially during the lean years, where we have had to rely on more Act 49 funds to supplement our appropriation. With the generosity of the General Assembly and the governor in the past couple of budgets, we've been able to rebound from that a little bit. But we would love to be in a position where we didn't rely on the ups and downs of the fee structure entirely. It's because it's unpredictable, and I think the audit committee that was established to look at that funding, particularly on the computer system augmentation fund, sees that it is not a reliable source of funding from year to year, unlike just saying we need X million dollars to fund our computer systems and getting that appropriation. So to predict whether it's going to stabilize, how it's going to stabilize, even if you have an up year, is that a trend? I don't know that we can say that, but for that reason, it is an unreliable source of funding.
So if for the layperson that may be watching, can you outline who those fees are collected from?
They're collected from the people that are accessing the justice system.
Okay, just the criminal justice system or civil as well?
No, it's civil. It's across. It's a traffic citation. It's anything from a traffic citation to a filing seeking a landlord-tenant dispute or what have you. It runs the gambit.
I'm not going to ask you whether you're anticipating an increase if marijuana is legalized. I'll let that rest. But do you know how Pennsylvania compares to other states in the percentage of judiciary funding that comes from fees versus state appropriations?
I don't know that off the top of my head, Representative, but I can tell you in talking with some of my other fellow state court administrators, I know that in several states, Arkansas comes immediately to mind. Their judicial computer system was solely funded by fees, and it was just a losing proposition. They were facing what we are now facing every year, which is, are we going to make it through another year to operate our statewide case management systems? So in Arkansas, they switched from a solely fee-funded system to an appropriated state funds situation.
Switching gears a little bit, I'd like to clear up some confusion, or have you clear up some confusion regarding the judiciary's salaries and expenses. Can you confirm what accounts you use for reimbursements for the Commonwealth, Supreme, and Superior Courts? It's my understanding that the Commonwealth Court has its own judge's expense account, the Superior its own, and the Justice expense account, which provides specific funding to reimburse travel, food, and lodging. Do these three accounts cover all of the expenses for those respective courts?
Yes.
Okay. There's no other accounts available to the judiciary to submit for reimbursement?
No, any travel related expenditures come out of the three line items for the three appellate courts.
Okay. And in an effort of transparency, all of those are subject to right to know request, correct?
Correct.
Thank you so very much. Thank you for your testimony.
Thank the gentlelady. Chairman Struzzi.
Thank you, Chairman. Well, I thank you all again for being here today. I'm not going to drag this out too much longer. I know it's getting late, but just a couple of questions related to cybersecurity. And it was mentioned, I believe, that one of the larger concerns or the bigger concerns are at the county level. How are cybersecurity projects, programs funded for the lower level courts?
Well, as I said before, Chairman, the county-based systems are run by the county governments, and so any cyber security protections are contracted and paid for by county governments.
Is there any money in this budget for the counties to upgrade their systems, update their systems?
No, there is not.
There is not, yet it's a major concern.
It is a major concern, but what we are focused on are the statewide systems that we manage. And I can tell you that for example, the trial court civil systems, we have no statewide case management systems. So those are handled at the county level, and there's approximately, they're either in-house design or there's about 12 existing vendors in place in the Commonwealth providing services for our civil trial courts. In the fall, I attended, along with our IT director and other IT staff, a cybersecurity summit of the Mid-Atlantic states. One of the things that came out of that summit was the recognition that we need to focus on what is happening in our local courts in terms of protection for cybersecurity, because Pennsylvania is not alone. New Jersey, New York, Maryland, Delaware, Virginia, they were all there sharing the same stories. So I think the National Center for State Courts is working on a model with federal partners that we can hopefully invest some money, infuse some money at the local level, but certainly look to doing some tabletop exercises, because part of preparedness is making sure that you have thought through how you're going to respond to an incident and how you're going to pivot when your websites or your systems come down.
I appreciate that. I think it's important that we try to support the counties, because a lot of their local budgets, they simply can't afford to do cybersecurity measures that are clearly needed. So I appreciate that at least you're focused on some sort of remedy. And then the problem-solving courts. I know we talked about that last year, and it was mentioned several times today. Those are truly effective, and I think it's important that in many cases, sometimes a crime is committed not with the intent of, I would say, they're committing a crime because of other factors in their life, whether it's mental health issues or substance abuse issues. So I think these courts really are preventing future crime and hopefully keeping people out of jail and prison. So as I said across the board today, I think all of us can support these problem-solving courts. And my point is, I know that there's no additional funding in there, and I know that you mentioned, you want to see that funding increased in the future, but I think this is truly an effective measure at preventing recidivism and preventing crime in our community. So I thank you all for your time today, and I appreciate you being here. Thank you.
Chairman. Thank the gentleman. Justices, real quick, I'm pretty sure you could estimate what I may ask about. This General Assembly over the last 7-8 years have done a lot of work in a bipartisan fashion around the sealing of criminal records. Since we did Clean Slate 3.0 at this point, while there have been some drug felonies sealed under Clean Slate, we've been a little disappointed at the number. Do you know what is causing the slowdown in our inability to seal more records under the new Clean Slate Act? What do you need to do to speed up the process with regards to what this General Assembly passed?
Chairman, we are aware of concerns that have been raised about I guess, concern, maybe our disappointment that the numbers are not as robust of individuals seeking to take advantage of Clean Slates 1 through 3. We're looking into them to see if there is anything on our side that is somehow hindering the access to those programs. As you know, we as a court have worked, and AOPC has worked diligently to implement all 3 levels with regard to changes in the system and working with the Pennsylvania State Police. Like I said, we understand that there is some concern there, and we're going to be looking into that to see if it's anything on our end that we can help with.
So far, we've sealed, I think the number's around 55 million cases since the implementation of Clean Slate back in 2018. So it has been by far one of the largest pieces of effective criminal justice reform in our Commonwealth. Would you guys commit with meeting with me and the advocates to come to consensus on what's happening, what needs to happen, so that we can make sure that Clean Slate 3.0 is as robust as 1 and 2.
Of course we will.
Okay, thank you. Second question, around fees. How much of your budget is generated from fees?
At latest, my latest understand, we're dealing with 11% right now. Now that's the 11% for purposes of the general operations. That's not the computer augmentation fund fees, the JCS fees, as I understand it, correct? So we're at about 11% of our overall operating budget is fee-based Act 49, and then the general appropriation. The UJS operations are entirely dependent upon the current fees that are existing under Act 64 and Act 120. There's a line item appropriation for a certain amount of money, but that the General Assembly, because they have to appropriate, you have to appropriate that money, but that appropriation is not, the fee generation is not keeping pace with that appropriation. That's the problem we're running into.
So I know that there are fees for court filing, you know, for lawyers that file and all this, but there are also fees for when people get tickets and all of those other kind of things that go into, I'm assuming, this 11%. Do you guys break it out to see how much are fees that are generated from the filing of court documents and fees that are generated from the adjudication of cases?
My finance staff is telling me that we do break it out. I don't have those numbers at the ready, but we can provide those to you.
Yeah, I would like to know how much is being generated, and maybe over a 3-year time period, from the adjudication of cases, separate from court filings and whatnot. The reason why I ask that, for me, and I think we've talked about this, so this is not a secret. I think it is. Trying to think of the proper word. It's wrong that a part of your budget is generated from the adjudication of cases. I believe that we should look at what that number is over the last 3 years and just fully fund the court system so that courts aren't depending on it. Now, I'm going to say something, this is not to impugn anybody's character, but in essence, I, as a judge, need to basically find a certain amount of folks guilty. I can't waive fees because I need those fees in order to fill the budget. That doesn't make sense, and it puts you all, and particularly the MJs and the district judges, in a precarious position, because you may want to waive fees, you may see a person who's struggling or whatever, but we can't do that because those fees are an underpinning of your court budget. So for me, it makes no sense, and it puts jurists in a precarious position where now these rulings that you're making, there's a financial tie to them for your budget. And I understand, you know, 3-4 years ago and before, we were not funding at the way we should be, and therefore these fees were even more important than they are today. I would love to know those numbers, because for me, I think it makes sense for us to see what those numbers are, and for us just to fully fund our court system as a co-equal branch of government. And whatever those fees are in the future, I mean, we could decide what else we want to do with it, where that money goes. We could reinvest that money. We could put that money into reentry services, something that I know, Justice Robinson, you and I care about. We could do something like that. But the court should not be dependent on a jurist and the fees that are attached to something that they are adjudicating in front of them. Would you agree with that?
Chairman, I think I agree with a lot of what you said. I think the problem for us right now is, you know, we have built a budget request based on what we understand the playing field is and the rules are right now. We need Act 41 reauthorized because 7% of an appropriation increase is not going to get us there this year. Mm-hmm. The JCS amount, the diversions over the years that we've had, the automatic diversion that happens, even though we don't have to deal with that until next year, we would like to see it gone. But more importantly, if you just look at the hard numbers, the General Assembly and the governor are very aware of what it costs our branch of government to run these very critical computer systems. The number is in there. The fees aren't keeping up with it. And we bear, and the citizens bear, the risk associated with the cyclical nature of these fees. You mentioned judges being tied to the financial benefit of it. During COVID and all those, in that period of time, if you look at these fee structures, we have heard anecdotally that even law enforcement is reticent to write somebody a ticket because of the fees that go along with it. They'd rather give them a warning. And that can impact the amount. There's just too many variables associated with a computer system or even a judicial budget operation for a branch of government that relies on fees. There's too many variables. So we support the idea of getting the risk out of the judiciary with regard to the fluctuation and unpredictability of the fee structure.
So in a perfect world, you would say that we should be getting out of the fees being a part of your budget and just do a straight allocation so that, and I don't want to say there's an incentive because I don't want to make it seem like, because that's not what I'm saying. But like, for me, it doesn't seem right that that is dependent on it. So in a perfect world, would you want to remove that?
In a perfect world, Chairman, absolutely. I think our numbers are our numbers, and like I said, the General Assembly knows what our numbers are every year. But the way it strikes right now is those numbers will change depending on what happens out there. And yeah, if we can get the flatline appropriation for JCS and for that 11%, you can have the fees and do with them whatever you want to do with them. We would rather have the money that we all know that we need to operate.
Thank you. So if whoever does that work, if you could get us what that actually looks like and break it out. I mean, no disrespect to my lawyer friends, but they could still pay to file. I mean, I'm okay with that. Although there are some who would say that filing fees is an access to justice issue as well, as there are folks who can't afford to file fees. But one mountain at a time. If we could, break that out, I would love to see what that looks like, because I think, you and I agree. I think we agree on the fact that if we can remove that, we should remove that and just fully fund the judiciary. And with that, I want to thank you all for being here and enjoying your afternoon with us at this budget hearing and answering our questions. We truly appreciate the work that the judiciary does in this Commonwealth. We thank you all for your service and your partnership and doing the best that we collectively can do for Pennsylvania. We will be back here tomorrow at 10 a.m. for the Department of Environmental Protection and the Department of Conservation and Natural Resources. We'll be back here at 10 a.m. with those two departments. And until then, this budget hearing is now adjourned.